Good morning and welcome to the House Environment Committee. This morning, we are going to walk through changes to H 723 and act relating to posting of land with our legislative council. Welcome.
Thank you. Happy to be here. My name is Bradley Shulman, Office of Legislative Counsel. I'm going to go ahead and share my screen with a copy of the bill. And I'm going to take a moment to set up these controls. There we go. Okay. So this bill is an amendment to House Bill number 723, an act relating to the posting of land. Format the bill is a strike all because we made some pretty substantial changes to the bill, and I will walk through what those changes are. This bill proposes to enable property owners to post their land against hunting, fishing, trapping, or taking of game or wild animals by either posting notice signs or purple paint markings. I'll walk through this bill because each of those requirements are slightly different. And
Excuse me, Bradley, we have one question from Representative Voss.
Trespassing, just walking. Is there another sign that people need to post, or can that be, is that an assumption on this?
that is not an assumption on this.
What's the question?
Or just walking, trespassing, like if you just want to hike on someone's land?
Well, no trespassing would prohibit walking.
Right, but there's nothing in here that says.
And if I may,
Yes.
the no trespassing law is a different statute with different requirements. And so a no trespassing sign should say no trespassing. And so this statute, and we'll go into that, only affects hunting, fishing, trapping, or taking of game or wild animals. If a property owner wanted to further restrict other kinds of activities, they have to post a no trespassing sign pursuant to the criminal statute. I have that written down. It's 13 VSA 3705. The interesting thing with the no trespassing sign in the criminal statute is that there's, you'll see in this bill that there are a lot of requirements to provide information to hunters about what is and is not permitted. But the no trespassing signs, that statute is fairly, a little more straightforward and about just posting the sign of no trespassing and then having it be reasonably, posting it in such a way that a reasonable person would be able to see it. And that would protect your property from criminal trespass.
So if you just had no trespassing signs, would that also forbid hunting, trapping, fishing?
So that is a potentially an open question and subject to different interpretations. So the Department of Fish and Wildlife has some guidance, and it's just guidance, so it's not an official rule. But they have guidance saying that if a property is posted against trespass, don't hunt on it. One could imagine, because these are two different statutes with two different rules, one could imagine a scenario where a hunter hunts on property with a no trespass sign, and the property owner wants to take a civil action against that person for actual damages, or wants to just one moment, and wants or contacts the police for a criminal violation because and I'll talk a little bit more about this too. No trespassing under Title 13 is a criminal statute. And so the police could potentially press some kind of charges against someone for trespassing on a person's property. Most violations under Title 10, fish and wildlife violations, are civil. And some are criminal, some are civil. And but most, I think the statutes were amended last year or 2 years ago to change the jurisdiction from the criminal court to the civil court for most violations under Title 10. And so those are civil violations. And so one can imagine a scenario where a hunter hunts on land that's posted against trespass, but doesn't mention signage in this way, and a legal challenge therein. And I think both sides have reasonable arguments on this. And it could be both sides would have reasonable arguments. I think one thing that I would want to impress upon the committee is that this statute is effectuating, if that's the word I want to use, but addresses a constitutional provision, right? It is giving, it is putting into law the constitutional provision that addresses a specific issue. So in Vermont law, excuse me, in Vermont law, individuals have the right to hunt on property that is not enclosed to hunting, and that is what the Constitution says. And so, because there's a constitutional right to hunt, and there's also a corresponding constitutional right to enclose your land from hunting, so there's two constitutional rights there that are in conflict. This statute, 10 VSA 5201, tries to effectuate those things such that both people with different sets of rights know what is correct and what is not correct, right? Hunters know what land is posted. Property owners know how to enclose their land from hunting if they so choose. So your question is a simple question, but it's a complex environment given our constitutional right to hunt, your constitutional right to enclose land, and the difference between civil penalties and criminal penalties on trespass. It's a complex issue.
So, thank you for asking that question. A property owner could, I'm surprised this hasn't been litigated. So a property owner, if I understand correctly, could post no trespass and expect that no one would be trespassing or hunting on their property. Meet the letter of the law and have legal grounds for not allowing hunting.
So,
and not have a strict posting rate.
Potentially. And I think a property owner in that situation might set themselves up for a conflict with hunters if they only post against trespass. Because posting against trespass does not necessarily impact the constitutional provision that this statute does, right? And because there's that constitutional right, because there's that constitutional right to hunt and a constitutional right to enclose your property from hunting if you would like, there are special things a person needs to do in order to engage in those constitutional rights. And so it is an open question of whether someone could post their property against trespass. I mentioned earlier that the Department of Fish and Wildlife has guidance saying that posting against, if you see a no trespass sign, don't hunt there. This is unofficial guidance. It's and they are because it's unofficial, they're welcome to change their minds. But it's a sticky question. And the guidance that we have from the Supreme Court is similarly unclear on these issues. And so there is, and I might need to refresh my recollection a little bit more thoroughly on this piece, but there is a very old Supreme Court case that talks about posting no trespass signs and whether that can exclude people from hunting. And it's unclear from that case whether this statute wasn't considered in that case. And so the Supreme Court said that, you might be able to get fined if you are hunting on someone's property if there's a no trespass sign posted. That's a Supreme Court case from the early 1900s. And we don't know if because the law has changed, we don't know how things would shake out today because there's different laws that are meant to effectuate an individual's rights to hunt and enclose their property. It's confusing. and there isn't, unfortunately, there just isn't clear instruction from the Supreme Court. There isn't a slam dunk either way on this piece. There could be a policy solution. It could be the case that, I mean, I don't want to propose a policy solution. If the committee asks me to, I can, but that might be a policy solution for the committee to consider. Whether posting a no trespass sign and just make it clear that is possible.
Representative Tagliavia,
I,
can see the
what you
gears.
brought up. What's that?
Thought I can see the gears turning. Do you have a question? Do you have a
Did you
question?
smell smoke? You said something about this question bringing up policy questions. Is it a good idea to discuss policy, to try to take away, to clear it up, not, don't get me wrong here, I'm not suggesting we make more restrictions, but to alleviate conflicts
That's what we're trying to do
that,
here.
that our wardens are gonna have to deal with, or
That's-
state police are gonna have.
Yes, and this is a piece of information that we needed, so, yeah, that's what we're absolutely working on. And, Representative Labor.
Thank you, Chip. As a landowner, I caught people trespassing on my land for the purpose of firewood extraction. So it's timber theft.
Yeah. Yes.
That was the reason for the no trespass sign. It had nothing to do with fishing or trapping. Well, that was 10 years ago. When I did catch them, I went up and interrogated them. I said, "Oh, we didn't know this was your land." Okay, so they went within the 300 feet at that time. So I guess my question is, why not just have a chat with those people? I did. They apologized. I said, "Well, take your wood out. You've already killed the tree." It was a beautiful yellow birch. 12-inch diameter.
That might have been overly reasonable of you. I'm a reasonable person.
Oh. They never trespassed again. So I think there was, at that time, separation of the definition of trespass versus posted for hunting, fishing, and trapping. At that time, you had to date and put your signature on the side, the yellow side, which clearly identified your purpose of posting.
Well,
If I may,
you may.
so and that is the law today. The law does require that if you want to prohibit hunting, fishing, trapping, taking game or wild animals, you have to post in particular that desire. If you want to exclude from other kinds of trespass, like taking of timber theft, a no trespassing sign would be the way to effectuate that. And now we're getting a little bit away from, we're getting more into kind of criminal law when we're talking about no trespass. But, if you don't have a no trespass sign and someone starts taking timber on your property and it's obvious that it's your property, you may still have a person, I shouldn't say you, but a person may still have some legal remedy in that situation, whether it's criminal or civil, even if it's not posted. I say that because now we're getting just a hair away from what the issue at hand, which is how does a landowner effectuate their legal rights to enclose their land from hunting, fishing, and trapping? And while it is related to trespass, and this committee could consider solutions to make that clearer for folks, the remedies and the certain actions that a property owner could take when faced in a certain situation, it is getting us a little bit a little away from the legal analysis here. So related questions, but focusing here on these issues here.
Yeah, so with that, I would like to continue with the language before us, but we may be asking you if there's time to walk us through that Title 13.
Yeah, I can show the statute, yeah. And so this statute is 10 VSA 5201. And we make some changes to his or her to conform with our practices. And has exclusive, so what we're doing here is we're changing the statute to make two ways that a person can post against hunting. I might just say post against hunting to include all of these other hunting, fishing, trapping, taking of game, or wild animals. I might just say hunting moving forward to save myself, to save my tongue. So prohibit hunting by maintaining signs, and this is the statute as currently written. Except I break it out because it is getting more complicated. So I break it out so it's easier for the public to understand. Shooting, trapping, or taking of game or wild animals is prohibited by permission only. Fishing or taking of fish is prohibited by permission only. Or hunting, fishing, trapping, or taking of game is prohibited or is by permission only. So you can prohibit, give permission, or prohibit or do both, you know, and so hunters or property owners have the option to prohibit these activities, permit these activities, or prohibit and permit some of the activities depending on their desires. The new piece here is maintaining paint markings on trees, posts, or other objects, provided that the marking shall consist of one painted line of purple paint that is a minimum of 8 inches in length and 1 inch wide, and be painted at between 3 and 5 feet above the ground level. So this is the purple paint provision. This provision is modeled after a proposed statute in New Hampshire. That statute did not pass. And a word of warning, if you look it up and you Google it, artificial intelligence, I think incorrectly says that it did pass, and it did not pass. And so it's been an interesting rabbit hole to dive in on that piece. But suffice to say, there was a proposed statute in New Hampshire, and that's what those requirements are based off of.
Aren't there other states that
There are other states.
have it in place?
That is correct. That is correct.
Presumably looked at those also.
I have. And for states that permit the painting and just the painting, it's usually one painted line, 8 inches. Sometimes it's 1 inch wide. Sometimes it's 2 inches wide. Sometimes it's 3 and 5 feet. Sometimes it's 3 and 6 feet. But this is kind of in line with those statutes. Some statutes require both painting markings and notice signs. We're not going that route, but that's a possibility as well. And then the permission only signs, nothing changes here. But if you're hunting by permission only, property owners shall contain their name and method by which they can be contacted so that a hunter can get permission. Notice signs are erected at or near the boundaries of the land and at each corner and not over 400 feet apart. So that's current law. I made a change here just to kind of, now we're clarifying, we're talking about notice signs in one place, paint markings in another. So I just changed the language to kind of make it consistent here. Paint markings, this is the new piece. Paint markings under this subsection shall be painted upon or near the boundaries of lands to be effective with the paint markings at each corner, not over 100 feet apart. And so this is a change from the notice signs. If you're doing paint markings, it's 100 feet. If you're doing the notice signs, it's 400 feet. That distinction is based on instruction that I received from the committee and is a policy choice that's not based on any objective reasoning. I will say that some statutes say 100 feet. And some statutes say 100 yards, and which is a very big difference. So that is the choice, right? To have it more or less frequent. And that's not based on anything that I did here. Notice signs or paint markings shall be maintained at all times. And then the instruction I've received is to take out the date requirement. And so we're just taking out the date requirement on the signs entirely. And then the notice sign shall be of standard size and design as the commissioner shall specify. And that's the current law. The owner or person posting lands with notice signs or paint markings shall record this posting annually in the clerk's office, the town, and the posting shall be valid and enforceable for 1 year after the date the posting is recording. So what I changed based on feedback from the committee, but I can change this back. In this section in this line that I have underlined here, it used to say 365 days after the date the posting is recorded. And when I did the walkthrough with this committee a couple of weeks ago, I think there was some feedback that 365 days felt awkward. And so I changed it to 1 year after the posting is recorded. I can change it back. But I just want to highlight that change. And then the recording forum, oh, was there a question?
Questions,
Okay.
Representative Sakowicz?
Just so I'm clear, Bradley, that line is specifically referencing the reporting in the town clerk's office.
That is correct. That is correct. So the recording still has to be annual. And the recording itself is effective 1 year after the date the recording is made. And that's what this is supposed to give effect to.
So under this new language, if a hunter wanted to know where land was prohibited or not prohibited for hunting, they could go to the town clerk and see parcel by parcel where that was in effect. And if a landowner did not record with the town clerk, but they had signs up, they would be considered not enclosed.
The second part, that is correct. The first part is, that is my assumption, is that the clerks would be able to provide this information. How easy that information is to get might depend on the clerk, the town, or how their record keeping. But the assumption would be that hunters would be able to go to the clerk and see what's posted ahead of time if they're planning their routes or planning their outings.
Representative.
That was my.
Oh, I'm sorry.
Good.
Okay, thank you. And then the $5 fee for recording, all of that stays the same. And so this is section D, and this has changed quite a bit. And so the statute used to say land posted as provided in subsection B of this section shall be enclosed for the purposes herein, right? And so what that meant was, as a reminder, we're giving life to a constitutional provision. You have the right to hunt. Property owners have the right to enclose their land. And so this section borrows that language from the constitutional provision and saying, okay, so when you post your land in accordance with subsection B, that it is enclosed for the purposes herein. Subsection B is the section about the notice signs, erecting the signs 400 feet. Now it's proposed to include paint markings. So subsection B talks about the signs and how you post them themselves. It does not incorporate the recording requirements as written in law right now. And so land could potentially be enclosed without being recorded. And there is a footnote in a Supreme Court case that suggests as much, that if you don't record your land, it is unclear whether that's for purposes of this statute. If you don't actually record it, it is not necessarily meaning that your land is enclosed. So what this proposes to do, and there's a reason for it, and I will get to it in a moment. What this proposes to do is make it clearer that the requirement is to both post your land in accordance with the set of this section and record it. And so that is a change, and there's a reason for that change based on the instruction I received from the committee. There's a reason for that change. One, to make it clear, which I think is kind of the assumption that you have to record to make it effective. But two, there's a reason for that, and I can go on. So last time we discussed property owner. The issue is we discussed property owners who attempt to post but might have one defect. One of the signs might be ripped. One of the signs might say 2024 instead of 2025. There might be some minor defect in one sign And the feedback, some of the committee took testimony that saying that the game warden would come out and say, because this one sign is ineffective, defective, the whole property is not posted against trespass. And so the instruction from the committee was to provide some kind of reasonableness standard that says that that would kind of correct that situation. And so long as the property owner is making a good faith effort or something, and we'll get into the language, that the land is enclosed for that purposes. So what the language here that we came up with is accidental or unintentional deviations from the requirements of subdivisions A and B of this section shall still be deemed effective to prohibit or permit by permission only hunting, fishing, trapping, or taking of game if the notice signs or paint markings would lead a reasonable person to believe that hunting, fishing, trapping, or taking of game is prohibited on the land. Property owners with actual notice that their notice signs or paint markings deviate from the requirements of the section shall take reasonable steps to ensure that their notice signs or paint markings comply with this section. So what this says is that you have requirements in subsection A, you have requirements in subsection B. As long as a reasonable person would look at those signs and determine that I'm not allowed to hunt here, or I can only hunt by permission here, that's still effective to enclose the land. What this does not give leeway to is the recording requirement. So individuals are still required to record, and they don't get an excuse for mistakes with recording requirement. So the recording requirement provides notice, or the notice statute provides notice. The recording requirement provides a way for hunters to determine if land is posted. And so property owners have to record, and this, as written, the committee is welcome to change this, but as written, this statute would not give property owners leeway to fail to record and still have their land enclosed for purposes of hunting, fishing, and trapping. There's a reason for that. Sometimes there are, I haven't looked at all the statutes, but I've seen some statutes where property owners get the benefit of hunting certain game without a license if they don't post their land. And so what this does is kind of has a little bit of checks and balances, because if a property owner is posting their land against hunting but doesn't record, the state might still give them the license benefit of not posting their land because they might not have an actual record that the land is posted. So this would kind of, in that very narrow scenario, this would kind of prevent that from happening, kind of a gamesmanship. That's not necessarily a problem that has been raised to the committee, but it's a potential issue. So the statute or this section of the statute is amended to give property owners some leeway with the actual notice signs or the paint markings. It does not give them leeway in recording, and it makes it clear that recording is a requirement to enclose the land.
Representative Austin.
Yeah. You can record electronically, if that would be useful.
With the town clerks?
Yeah.
I'm not sure. I'm not sure if they have an online way to do that.
Representative Labor.
Many of my towns, the town clerk's office is open 1/2 day of 1 week. So is there a way we could get a leeway in? Posting must have occurred 30 days up to 30 days after physical posting of the land.
You mean recording would?
Recording it.
Yeah. And that would be a policy decision for the committee. But that's certainly a possibility is to give like some kind of leeway for that kind of situation.
But this statute is no longer requiring a landowner to register by a certain date. It's just 1 year from when they register. So there's a fair amount of flexibility built in on that side of it right now.
That is a correct interpretation of the statute as written. Say the draft statute.
Further questions on this for Bradley? kind of,
Just one more time on to get no trespassing on, and all this all on one sign would take an act of Congress, it sounds like. Is that correct?
No, no. And so when I say a constitutional provision, I mean a state constitutional provision.
Mhm.
And so,
That was,
oh.
well,
sorry.
but that's a segue. If folks are finished with this, I
Yeah.
would like to walk through
Okay.
that Title 13.
And
Sorry.
so I'm going to,
One question or a question from Representative Nora.
Thank you, Chair. Just, maybe just some technicalities here. One being that if we are trying to reference in section D there on page 3, reference back to the Constitution. The Constitution uses that funny word enclosed rather than enclosed. Should we stick with that same verbiage? I know that's
So
extremely.
what line are you on?
Line 9 on page 3.
yeah. And so to give some context, the Constitution spells the word enclosed with an I. And most often today we spell it with an E, and it would not be necessary.
Okay.
To
Sure that people weren't going to point to that.
yeah. I imagine if someone, I mean, nothing stops anyone from trying interesting arguments in court. However, I don't see a judge ever. Yeah, no, but that's an interesting question.
The
Control that.
other and maybe more sticky question is it doesn't appear that any of the posting requirements require anybody to identify the landowner's name on any of the sign or any kind of contact information. So if it says by permission only, how are you going to know whose permission and how to get it?
That's a good question, and I can go up we're in subsection A on page 2, line 4. Permission only signs authorized under the 6th section shall contain the owner's name and method by which to contact the property owner or a person authorized to provide permission to hunt, fish, trap, property.
Yeah, there. Okay, very good. Now, so then obviously a painted line can't have any information. So,
That's correct.
so how do we accommodate that?
So the painting would only serve to prohibit hunting, fishing, trapping, taking of game or wild animals. And so it would not be sufficient to grant by permission only. You would need a separate sign to do that.
Interesting. Yeah, I wonder about, because one of the things we're trying to address is the ease of posting to property owners. What if, and I actually, in my mind's eye, I was imagining that at the access point, someone would have a sign that said who they were and that it was posted, but that around the non-open parts of the parcel, you'd see paint. I guess that's
Like on the
what I was imagining.
road frontage, something like that.
Yeah, well, where an obvious person might walk in from, the road or their own, maybe a neighboring property or a class 4 road or trail or something.
I guess I'm really not comfortable with the paint only option. It seems to me, just simply because there's then therefore no indication of who posted it. And that could lead to false posting by somebody else. Really not comfortable with that. I'm not even all that comfortable with just painting at all, just because it could wear off. And it's just so many problems with paint being durable enough and visible enough and on the right color, and so many nuances there. But a sign is a sign of the sign. The words say what the words say, and the words are in statute here. It's all very clear.
Can you remind us which states have implemented this have implemented it?
There's about 20 states. So places like Maine have done it. Tennessee requires words and paints. Arizona has done it. Idaho recently changed their statute. They used to have, you could post against hunting, fishing, or you could post to prohibit and then they changed their statute to say that it's hunting on private property is prohibited. And so they don't have their statute anymore because they made hunting on private property more restricted unless it's by permission only. And then there are a number of other statutes I could pull up my list, but
Would you happen to know which of the 20 also have a constitutional right for hunting?
I do have that information, but I wouldn't be able to pull it off the top of my head.
Okay, that would be the pool we'd want to look at.
So let me take a note on this. So provide information to the committee on states of constitutional rights and painting. Is that correct? A constitutional right to hunt and statutes that prohibit property owners to prohibit hunting by painting.
Yeah, I mean, I don't have a sense of the universe of states that have it in their constitution, but if it's not too many, I'd be curious just to hear how they address this broadly
It's about half.
with or, so 25 states.
Yeah.
Okay, well, so, I don't want you to spend a ton of time, but a sampling of how they address it would help, regardless of whether it's paint or not.
Yeah, I have those two lists separately, but I'll combine and compare.
Great. Others, I know have questions.
Yeah.
Representative Pritchard.
Thank you. So Bradley, getting back, and I know I asked these questions a couple times previously, concerns I have, and know they're not in this bill, is one of them, what was I think as Representative North said, I'm concerned about painting up the state of Vermont. Easy thing to do. And the other thing is that we had talked about is if somebody does that, what penalties do they face if they're not a homeowner or landowner or agent of landowner? And how do you correct that? I mean, it's easy to remove a sign. It's not so easy to remove a paint. There's no penalties. There's nothing that says, one of the things that we had talked about is having how long, is this paint good for? When should it be refreshed? Every 3 years, every 5 years, 10 years? And I think that's important, to be in this bill, and none of it's there. So.
If I may. So I drafted a bill with instruction from the committee that I received. And I'm happy to draft whatever instruction the committee would like to give me. That said, I do want to share that there is a statute, 10 VSA 5204, that provides a penalty of not less than $25, not more than $100, for people who poach. So if hunting is prohibited on property and you hunt anyway, there's a civil penalty. And
$25?
$25 to $100. It's a civil penalty. And that penalty also goes toward people who mutilate or deface the notice signs posted pursuant to the bill that we're talking about. It does not create a penalty for people who post land just for, yeah, there you go. And against the property owner's wishes. So a third party coming out and painting that it doesn't contemplate that. Property owners do have the right under the statute to also engage in a civil action against someone who violates their rights in this way. So that is the law as it stands on that piece.
Representative Austin.
Would it be possible to put in terms of the posting at the town clerk, that if put in an option where people could do it electronically to, allow people, if they can, to be able to do it electronic? That's one. And then another state is using Onyx, which is a way to use your phone to see, or your computer to see posted land. So that hunters can look ahead And, but it's all electronic, and I was just wondering if that would be if that would be a possibility.
I think that would be a good question for our clerks. And because I'm not familiar with the systems that they use,
Right.
the technology that's available to them,
It
whether
would
it's.
more be the posting,
Mhm.
on a tree, there'd be something that would say, go to Onyx, or, have some kind of QR code or something where they could go and they could see whether the land was posted or not.
I
There is a
just
state-
remind you that what Representative Labor just brought up, which is some town clerks are on a shoestring.
Right.
Open half a day a week.
But this
So,
one could do
I think-
anything for town clerks.
well, but the first part of your question, registering electronically.
Oh, okay.
Anyway, Representative Tagliavia.
To Representative Austin's point, I think it would have an effect on town clerks on Onyx. There is a notice that says that they are not 100% accurate because of dates of land transfers,
Yeah.
and that you need to double check. It's stated on that.
I would say we have a lot here to debate and we
Yeah.
should make it more complex.
Yeah.
I got reaction there.
Trying to make it easier for landowners, that's all.
So I'd love to take a minute to look at that Title 13 section, if you're okay with that, Bradley. I don't want to put you on the spot. Walking through it.
I'm going to unshare my screen and reshare Westlaw.
A comment?
Yeah.
Yes.
I think one of the things that we have done, or that the current proposal does, is eliminate the dating of any markings. So that at least makes them permanent. Once you've posted it once, you don't literally, the way it's worded now, ever have to go back around and check the signs to make sure, other than that whole reasonableness statement. Like if somebody says, oh, you're missing a sign on your back 40 over there, you got to go fix that. But a lack of a refresh period to Representative's point, Representative Pritchard. But I don't know, I don't know that permanent posting once and done forever. I used to get signs that are 5, 10, 15 years old. Nothing lasts that long. I mean, painting your house does not last that long.
You got the wrong painter.
Final siding.
Go to Sherman, then you.
Yeah, yep. I mean, I think there's stuff for us to be thinking about here.
But we did add in and record it.
Yeah. All right, let's, is this, this isn't.
This is the unlawful trespass statute, and I
Should we, go Vermont statutes on.
oh, I'm sorry. Yeah, I just had Westlaw up. And let me just, I'll get us to Vermont statutes online. There we go. Okay. Just keep looking back to make sure that I'm sharing what I'm actually sharing. Okay. And so this is Title 13. And Title 13 is crimes and criminal procedure. And this chapter talks about trespass. And so a person shall be imprisoned for not more than 3 months and fined not more than $500 or both. If without legal authority or the consent of the person in lawful possession, the person enters and remains in the land or in any place as to which the notice of trespass is given by. So basically, creates a crime if a property owner says no trespassing, and it gives the property owner options to do that. One, by telling the person, so actual communication, and so you confront someone, please leave my land. That's enough. Signs or placards so designed and situated as to give reasonable notice, or in the case of abandoned property, signs or placards posted by the owner, the owner's agent, law enforcement officer so designated and situated to give reasonable notice, or actual communication by a law enforcement officer. And the rest of the statute talks about abandoned property, prosecutions for the offenses, motor vehicles, entering a residence. I think the piece at the top here is most relevant to us. I can walk through the rest of it if you'd like, but the piece at the top of it is most relevant to us because it talks about how we give notice in criminal law to notice against trespass. So you can tell someone and you can post signs and placards designed and situated to give reasonable notice. And so there is a little bit more litigation on this piece. I recall a Supreme Court decision where an individual is being prosecuted for criminal trespass and their defense was, I didn't read the sign. And the Supreme Court says you don't need to actually read the sign. They just need to be, the signs or placards need to be designed and situated as to give reasonable notice. So it doesn't actually even require the person to read it so long as the court would make a finding that the signs or placards are designed and situated to give reasonable notice. In the law, when we use the word actual notice means that we know that a person has that knowledge, right? You tell them, we know that they've read it. That's why we mean by actual notice. And because Section B about the signs and placards just says reasonable notice, that's a more objective standard, right? So we're not really thinking about the subjective thoughts or opinions of the person who is trespassing. We're looking at an objective reasonable person. Would an objective reasonable person walk onto this land and determine whether or not it's posted against trespass? And so if you have your blinders on and you say, I don't see these signs, it's not necessarily a defense when the signs are posted, and a reasonable person would see those.
This is so interestingly, it's almost like the other opposite extreme. And I have a very hard time wrapping my non-lawyer mind around how hunting is not trespass, like your physical being on someone's land that is reasonably posted, no trespassing, couldn't fall under this statute.
That's a good question. And I think that it is because the statute that 723 purports to amend gives effect to a constitutional right. These two things are put in related but separate buckets. And it doesn't necessarily have to be that way. But as written, and as the state has chosen to effectuate the constitutional right to hunt and the constitutional right to enclose your land, they put these things in separate buckets. Practically speaking, if a sign says no trespass, even the Department of Fish and Wildlife has guidance saying that don't hunt there. Someone could make an argument, and it could wind up at the Supreme Court whether that's sufficient. But as written, they are separate and arguably don't affect each other.
Representative Sadkowitz.
And just to follow up on the chair's comment, and just to make it in my mind just a little more pointed, perhaps I just want to make sure I understand this right, that we're in a situation where a landowner could post no trespass for a person who's on their property, and they could tell them basically, please don't come back, and they wouldn't be allowed to come back under this criminal statute. But if they were to then go out and get a hunting license, they could come back with a rifle, and that potentially could be okay. That strikes me as being a problem. And I know you're just telling me what the situation is. I'm
Right.
making a comment that this seems pretty weird.
And I think that that's a fair reading of these statutes. And it is an open question what the court would do if it rose to that level.
Representative Tagliavia.
The, keeping the two separate and related but separate buckets. Has it been kept that way to be sure that the constitutional right to hunt is not diminished?
I wouldn't be able to comment on the intent or the policy rationale I wouldn't be able to comment on that piece, right? And all I can say to that issue is that they treat related but different ideas differently. And because one is a constitutional right to hunt and also a constitutional right to enclose, and those are two rights, right? In the same statute, or excuse me, the same provision of the Constitution, you have two things that are at odds in a way. Doesn't necessarily mean it's a fight or a conflict or a bad thing. It just means that they're conflicting and can't both exist at the same time without clarity. And so what I can say is that 5201 is meant to kind of create a scenario where we know we can operate with both of those provisions in some kind of harmony, as opposed to having those conflicts. Beyond that, whether the importance of the right to hunt or the importance of the right to enclose your property takes a precedence or has some kind of impact here, I wouldn't be able to comment on that piece.
With respect to Representative Sakowitz's question, I live in Orange County. Could a simple no trespass order served by the sheriff in the county help to stop the situation that Representative Sakowitz brought out? It would be obviously more work, but would it help?
I think potentially a trespass order could be designed in such a way to have a person stay out of the property for all purposes. Sometimes trespass orders are particular, sometimes they're broad.
Representative Chapin and then
I got a number of thoughts going on. I guess I'll just make an observation that I feel like, so we're working in this bill now to really solve two problems that have come to us. One pretty recently around just a lot of folks who are seniors or have mobility issues, disabilities, saying, the ability to post my land is too restrictive. I need a constitutional right to post my land. I'd like to be able to do it. Please help us. And then we've also had, a long-standing, for all my years I've been here, it's only 4, but a lot of problems brought to us around conflicts on land between hunters, particularly hounders, and landowners that have gotten very close to violent. And law enforcement doesn't seem to have the tools or the guidance with the tools. And I'm not sure if they don't have the tools, because what you're showing us suggests it hasn't been clarified by the courts whether this tool can be used to address that situation that was just described. So on that problem that we're talking about right now, we're really trying to reduce conflicts. And so one of my observations and curiosities is just, is law enforcement having so much trouble? Do the police just direct to the wardens, and the wardens have this long history of sort of looking at the postings in such detail and maybe they're not used. I'm just trying to understand, and this isn't a question necessarily for you, Bradley, but I wonder if we could get a lot more information from talking with law enforcement that get called to these conflicts and trying to understand the tools they do or don't have to hold people accountable. And I'm confused about that. But if they really don't have the tools, then, that's where we should be working on this. But I'm not sure that they don't. Frankly. If somebody comes in and damages your personal property, like the signs you have up posting your land, like my understanding, if somebody comes in and damages your home or your garage, law enforcement have tools to help landowners with that. And I don't know why that wouldn't apply to your land posting signs or unlawfully painting up a whole bunch of your trees with something that posts your property without your permission. I think we have a lot of laws in place to help people in general and landowners in particular at that situation. And I'm not understanding why those aren't always well applied. So that's a curiosity. Question for you, Bradley, is around this sort of the tension between these constitutional. I'm just wondering if you can see a parallel. So I did sit on judiciary for my first biennium, and I learned a lot in that realm. I learned a lot about the words reasonableness and actual communication and how much those kinds of words make a big difference in how we can hold people accountable. And they seem like really reasonable things related to this constitutional tug and pull. So I'm thinking about free speech and violence. I'm thinking about other places where constitutional, like civil, I'm thinking about other places that we have that. And I'm just wondering if you can make an analogy to another constitutional pull in two directions where we use things like reasonableness or, we have good tools to be more clear when something crosses the line and is no longer your constitutional right, but an unlawful action.
That is an excellent question. And, what I'm thinking of when you first say that is, regulations of speech, right? And so we have the right to free speech. And we have the right to really bad speech, right? Or I shouldn't say bad speech, right? But speech that some people think is offensive or harmful or derogatory, things of that sort. But there are some things that you can't speak. You can't impersonate a law enforcement officer and say, I'm a police. Well, I'm a police officer, and I'm arresting you, or something of that sort, right? Even though that could be potentially a form of speech, that kind of impersonation is unlawful, and so it kind of it leads to the question of how do you suss out what is protected speech and what is not protected speech. And those aren't easy. There isn't easy and clear guidance, and it's something that the Supreme Court, so long as we have the right to free speech, the Supreme Court will always be addressing those issues and those kind of like tug and pull kind of questions of can you have do you have the right to materials that some people think are offensive, right? A right to books that people think are offensive in a public library or something of the sort. And so that kind of tug and pull between an individual's right and then the state's interest in potentially limiting some speech for certain reasons might come into play there. But you won't get any more clear guidance from that framework for this issue because it just gets so messy. I would have to think about it a little bit more if there's something more narrow that I could analogize this to. And I would have to think about that more. But suffice to say, my answer at this point is that these issues are just messy, and it is. I think there are ways to make it clearer here, but it's never going to be easy, and there's always going to be conflicts.
What I'm hearing is definitely in these situations with constitutional pulls in two different directions, it can be really messy, and it can be very much the courts who are interpreting this. But in this case, we've actually got pretty good clarity because people are just freely allowed to post their land. And so we just need to make sure that how they do that and how what tools law enforcement have. Okay. When you say that now, I feel like this situation's really clear.
Right. Yeah. And one of the issues that was raised in testimony, and I haven't seen all the testimony, but I've seen a lot of it. But one of the issues that was raised in testimony is a game warden saying that, one sign was not dated, so the whole property is not posted, right? And is that even the law now?
That is that.
And some game wardens might say yes, and some game wardens might say no. And so that is a good question for game wardens, a good question for police. When you're tasked with these issues, what prevents you, if anything, from taking action? And that might shed some light on holes in the policy that the committee could address. I don't have an answer what those are, but I think that those are good questions to explore with testimony.
Thank you. It's 10 o'clock. I think. Let Representative Morris have one last question. Just a question?
Thank you.
And then we're gonna take a break.
All right, thanks for coming in. I want to move back to the bill at hand here, 723. And on page 3, section D, we've added in, right now, we're looking at a reasonable for posting land, either signs or paint, et cetera, et cetera. But it also includes section A, which is the property owner's right to post.
Mhm.
And we're adding in and recorded
Mhm.
as to combine that. Is that reasonableness also applying to the landowner? So if they don't record their posted land
Okay, yeah.
annually?
I can provide some clarity to that question. The reasonableness standard the reasonableness exception, right, does not currently apply to recording, right? And so you either do it or you don't. And that is an objective standard. There's no wiggle room for a landowner to fail to record. What this gives a little wiggle room to is making the actual postings or making the actual paint markings.
Right.
And then the content of the posting or like the spacing of the paint markings and things. That's the only thing that gets the wiggle room here.
Okay, not the landowner's responsibility to record.
That's correct.
Perfect, thank you.
But they don't have to do it on the sign. They can just go to the town clerks, right? They don't need to go to each sign and change the date.
There is no date requirement now. I mean, this bill proposes
Right.
to remove the date requirement.
Right. That's a big help.
With that, we'll take a 5-minute break. Thank you, Bradley.
Thank you.